Okay, I think we're almost ready to get started. Okie doke. Okay, then I think we can begin. Hi, everybody. Thank you for joining us at a Friday lunchtime. Today we have 53 people on the call right now, which is an amazing turnout. So really glad that you made time to join us here for this very important conversation. My name is Avery. I'm a lawyer with the John Howard Society of Ontario, and I'll speak about my work a bit more later. But first, I just wanted to say that this is an Access to Justice Week event held by the Law Society of Ontario, and you can look up on their website. I believe it's in the social media ad. So some of you actually may be here because you saw it, an ad with the Law Society. But for those who came through a different means, like through social, you can check out their website. They have a lot of really great events. We actually have one more event this afternoon at 3. And specifically, I'd like to thank Nzinga, Winna, and Sheena for making this event possible. Okay, I'm going to hand it over to Sophia and just become a panelist now. Sophia.
Thanks so much, Avery. Welcome, everyone. My name is Sophia Hussain. I am a lawyer and a senior policy analyst at the John Howard Society of Ontario. This subject is one that I'm definitely passionate about and is something that we do a lot of work on at the John Howard Society of Ontario. So I'm really honored and thrilled to be moderating this discussion today with these fantastic panelists. So the topic today is breaking down the unfair stigma of a criminal record. And we know that having a criminal record is common. In fact, 4 million Canadians have a criminal record. That's 1 out of every 9 people. And the vast majority have struggled to overcome social disadvantages, have paid their debt to society, and are trying to build a productive future for themselves and their families, yet still battle against this stigma that prevents further opportunities, employment, etc. And that's what we're talking about today with these 4 panelists. So the way we'll do it today, we have each panelist will give a bit of information about the work that they're doing and their perspectives on this issue. And then we'll go into a bit of a moderated discussion, followed by some questions from you from the audience. So feel free to put questions in the Q&A section there. It should be on the bottom of your screen. And we will definitely get to those later on in the presentation. So I'll start us off by just sharing a bit of information about each of the panelists and what they're going to be sharing with us today, and then I'll hand it off to them. So the first speaker today will be Samantha McAleese, who is a PhD candidate at Carleton University. Her research examines the changes made to Canada's pardon system and the impact of these changes on people with criminal records, and the work of nonprofit organizations that provide community-based supports. She'll start us off by speaking to the progress on cannabis amnesty, the status of broader reforms of the Criminal Records Act. Next, we'll go to Abby Deschman, who's a lawyer and the director of the Criminal Justice Program at the Canadian Civil Liberties Association. She's currently co-leading a public advocacy campaign seeking the federal government to adopt a spent regime by which many criminal records would be automatically sealed after a certain period of time. She'll share with us some information about that campaign. Kemi Anazodu is an assistant professor at the Odette School of Business in the University of Windsor. Her research focuses on stigma, identity, and the employment experience for marginalized populations. Kemi will share some insights on managing socially stigmatized identity and the impact on employment. And last but not least, Avery Au is a lawyer, founder of the Law and Design Lab, and currently at the John Howard Society of Ontario, where he leads the Fair Chance Hiring Initiative. Avery will share some information about the campaign, including the rationale for this approach and next steps. So like I said, each panelist will start with some information, then we'll go into a bit of a broader discussion with all panelists. So without further ado, I'll pass it off to you, Samantha.
All right, great. And just a quick thumbs up from folks that you can see my screen now. Okay, great. Hi, everyone, and thanks so much for everyone who's joining today. I will be kind of speeding through some things very quickly now, but I know we're going to have a lot of time for discussion and questions after. So if I've gone through something too fast and you want to know more, just feel free to follow up. So first, I want to let you all know a bit about how I got here, how I got to my research and the advocacy work that I've been doing for several years now around the Criminal Records Act. So this all started when I worked frontline for the John Howard Society here in Ottawa. I worked in a couple of different programs while I was there, both in education and employment. But one of my kind of off the side of my desk jobs was helping people apply for pardons. And the quote you're seeing on the screen now is from Sabrina, the first person I assisted through the pardon process successfully. So Sabrina needed a pardon so that she could complete her training as a healthcare professional. And after she received her pardon, she'd hoped that others like her would also benefit from a pardon so that the burden of a criminal record could be lifted from their shoulders as well. But soon after I worked with Sabrina, there was a major overhaul to the Criminal Records Act under the Harper government. I definitely don't have the time to go over all of that in detail. I'm sure that many people on the call are aware. But this slide here is kind of my best attempt to quickly sum up those changes. So you can see there was an increase in wait times before eligibility. There was a significant increase in cost that has since gone up even more. And there was new criteria that actually exempt some people with criminal records from applying to have them sealed. So very different. The record suspension regime is very different from the original kind of pardon system that Sabrina benefited from. Following these changes that took place between 2010 and 2012, there was a lot of reaction from criminologists, from human rights activists, from people with criminal records, from frontline workers, from legal professionals. And there was an immediate acknowledgement that this was a terrible move that would not at all contribute to public safety. So even at the time, we had folks like Steve Sullivan, who is the federal ombudsman for victims of crime. He was speaking out against the changes, saying that this was going to make it a lot harder for folks with criminal records in the community. And we saw challenge and resistance to this in the media. So we had some journalists who were doing great work at critical reporting on the changes. There were public forums held both here in Ottawa and elsewhere to highlight the harms caused by the new record suspension regime. And then we saw several constitutional challenges and public consultations that confirmed, the unnecessarily punitive effects of the shift from pardons to record suspensions. So first, there was a successful challenge out in BC against the retroactive changes to the Criminal Records Act. And then there was a successful challenge in Ontario, led by a lawyer here in Ottawa, Michael Spratt. And then finally, there was a third challenge out of Quebec that applied nationally, and I'll get back to all of this in a second. Okay, so in 2016, new Liberal federal government after a decade of Harper conservatives, and one of the first promises made by Public Safety Minister Ralph Goodale is that there will be an overhaul of the record suspension regime. So great, good news. There was a lot of excitement around that promise. Only not so great. So in fact, despite several, all the constitutional challenges that were ongoing, the public consultation processes that indicated support for reform, it took a while to see some movement. So just sharing the last tweet that I ever got from Public Safety, which was in 2017, saying that, changes were coming. Then in 2018, we of course start to talk about pot pardons. And for some, this felt like a good opportunity for public safety to move forward on their previous promise to overhaul the entire process for all folks with criminal records. But for many, Bill C-93 fell short. So the biggest conversation at the time was about the difference between kind of suspension and expungement. And the folks at the Campaign for Cannabis Amnesty really led this work. So they did a lot of public work, kind of familiarizing people with the record suspension process and pushing for kind of full and automatic expungement of cannabis possession records. So in short, expungement would have more appropriately acknowledged the harms directed at Black and Indigenous peoples and communities across Canada who were heavily targeted by prohibition laws. And we can see a little bit of that on this graphic here that was actually produced by the NDP during discussions of Bill C-93. So they were also pushing for expungement, and you can see kind of the stats here around how both Indigenous and Black people across the country were more likely to be arrested and also incarcerated for cannabis-related offenses. So as Parliament was working through C-93, there were other options available. So NDP MP Murray Rankin had introduced C-415, which outlined a process for full expungement of cannabis records. And Senator Kim Pate also had S-258 at the time, which did the same, but also outlined broader reforms to the Criminal Records Act as well. And Senator Pate has now introduced, a version of her bill several times in the Senate, kind of each time Parliament comes back after either a election or a pause. But we did end up with C-93, in my opinion, which I've shared quite publicly a few times, a completely lackluster approach for several reasons. So again, a cannabis record suspension process does not adequately address the historical harms and injustice experienced by Black and Indigenous people under prohibition. And that alone should have been reason enough for the government to be a bit bolder in this regard. But also, other issues that we know about record suspensions, is that they don't guarantee you travel across borders, especially to the US, especially when it's a drug-related offense. There are still costs associated with applying for a cannabis record suspension. There's still paperwork and bureaucracy associated with it. And we know from the low uptake, and I'm not sure about the current numbers, but I know from March 2021, it was reported that fewer than 400 people had received a cannabis record suspension. So we know that this isn't having the impact that advocates had hoped for. There were concerns shared early on that people living in rural and remote communities would be least likely to know about or to be able to apply for a cannabis record suspension. And there are so many other ways that this process excludes those who are made most vulnerable. So yeah, I definitely wasn't alone in my critiques of C-93. I think it was best summed up by Matt Dubé, who dubbed it a bare minimum approach to cannabis amnesty. Okay, so back now to the constitutional challenges that I mentioned, and to quickly situate that along with C-93 and kind of the entire record suspension process. So because of the 3 successful court challenges that we've already seen against, the changes that were made in 2010 and 2012, there's now like a multi-tiered pardon/record suspension process. So if your only offense is simple possession of cannabis, there's an entirely separate application process. For everyone else, there's kind of these other systems depending on when you committed your most recent offense. So you can kind of see on the screen, and this is all from the Parole Board of Canada's website. If you committed your most recent offense before June 29th, 2010, then you fall under, the old pardon system criteria. So before all the Harper changes. If you committed your most recent offense between June 29th, 2010 and March 12th, 2012, you fall under the second set of criteria, so with increased wait times in some instances. And then finally, if you committed your most recent offense on or after March 13th, 2012, then you apply under the current record suspension regime. And again, there are, exclusion criteria that prevent folks from applying altogether. And it's a extremely kind of long, lengthy bureaucratic process filled with lots of paperwork and other costs on top of the application fee. So in conclusion, this is kind of my sum up. I've been, talking about record suspensions and the Criminal Records Act for so long, and it's really just become a mess. And it's definitely not fine. And while we did see some movement with the introduction of Bill C-31 before the election, we need to be far more ambitious to address not only the harms caused by the record suspension regime, but also the shortcomings of C-93. And I can talk later in the discussion about how we also need to think more about how criminal records impact things like housing and some stuff that's come up in my own research, but I think I'll leave it with this for now so that others can kind of talk about how we're working at this point to make things better.
Thanks so much, Samantha. I'll turn it over to Abby next.
Great, thanks. And again, I echo my thanks for the convening of the panel and also everybody who's joined us today. So Samantha's introduction and background was perfect setup for what I hope to talk about, which is what do we do with this dumpster fire of a Criminal Records Act system. So starting earlier this year, CCLA, as well as John Howard Society and a number of other organizations that work on criminal justice issues, started to chat about, where were we on record suspension reform, what was happening. We had all these outstanding promises from the federal government and had yet to see any real concrete legislative efforts from the government itself that would tackle the really, really harmful changes that had been made to the record suspension process that Samantha outlined that had come into play over the past 10 years. So we had the conversation about expungement for possession for marijuana, really disappointing outcomes from that, and we had nothing to tackle the changes to the eligibility, to the wait times, to the really disenfranchising process that had been put in place over the last 10 years. So we started to gather a coalition, and we're still building momentum. If you look on our website or try to Google, coalition record suspension CCLA, you won't see anything yet because we're still working in the background on it. We haven't launched publicly, but we have been working really hard to gather really, really broad group of directly affected individuals, civil society organizations to all come together and push for a spent records regime. So what do we mean by a spent records regime? What would we like to see? We would like to see pardons, record suspensions become automatic. Right? We think that right now the process that people are being put through, which is a very high applications fee, which is many years of wait time, which is trying to gather a really complex paper trail that itself takes, sometimes a year to gather all of this paperwork and then send that to the parole board to prove that they deserve a record suspension, is intensely discriminatory and really undermines people's individual roads to stability, but also from a community and broader systemic discrimination perspective, just reproduces and compounds upon the barriers that communities that are already over-policed and criminalized, so it includes racialized Black communities, Indigenous communities, individuals facing mental health issues, addictions, people experiencing precarious housing, all of those communities that we focus on as targets of discrimination by the criminal justice system, this compounds that discrimination, pushes it out into housing, pushes it out into jobs and community engagement, and just has, you know, very long-lasting repercussions for people. So why are we putting people through such extended wait periods and such a bureaucratic system? What do we think we're achieving by this? Because we certainly aren't achieving stability for people who are on the margins. We certainly aren't supporting rehabilitation and reintegration, and we certainly aren't achieving public safety in jobs or elsewhere by wildly relying on criminal records. So we started to gather a coalition of people that would push for the process to become automatic, where people don't have to assemble reams of paperwork and pay very high fees to have this application processed by the federal government, but that if you had successfully, completed your sentence and didn't have any other findings of guilt or convictions within a certain period of time, that record would fall away. You know, it would automatically become suspended. And in that way, we would be, you know, not only undoing the harms that came into play through some of the legislative reforms of previous governments, but actually moving the system forward to recognize that, you know, widespread criminal record checks are barriers to public safety. They are re-traumatizing people who are trying to put their lives back together and compounding discrimination that already exists. After we started this work, the government introduced C31, right? So Samantha briefly mentioned C31. So C31 was introduced before the election, just before the election, and it would have enacted some changes that would have undoubtedly made an enormous difference to some people's lives. So it proposed to roll back some of the waiting periods. It would have eliminated a really horrific bureaucratic situation where people didn't know they had fines or didn't pay very minimal fines many, many years ago and have been waiting, and then, you know, 5-10 years later go to apply for their part in the record suspension and find that because they didn't pay their fine, then they had not been able to start their waiting period and were put another 5 or 10 years out. So, you know, some of those just objectively really horrific situations would have been addressed had this bill passed. But, you know, the intensely disappointing thing was, you know, not only did the government not do anything, they introduced this bill so close to what we all knew was the election that there was no way it was going to pass. This bill was introduced with no hope of passage. It was, put out there as, you know, we're doing something, but it wasn't going to be meaningful change for people because it had no hope of becoming law. So what position are we in right now? So we are actively building a movement, and I'm going to put my email in the chat for any of you out there who either as directly affected individuals, as professionals, you know, actually any way that you might relate to this issue and want to participate in this push for meaningful law reform. We are very much welcoming people from all kinds of positions. So we are actively pushing for the government to retool their approach to this. So yes, the changes in C31 do need to be made. We need the government to go further. There's broad support for automatic record suspensions or a spent regime. It doesn't make any sense to make people jump through these hoops, and we're undermining public safety, increasing the likelihood of future victimization, and really just compounding discriminatory barriers by continuing to prop up the system. So that's what we're pushing for. It's a political advocacy campaign at this point, hoping to make a bit of noise and see some more progressive change soon, right? I think this has to happen soon. We're not, in this to wait another couple of years to get another Bill C31 that dies on another order paper. So that's what we're working on.
Thanks so much, Abby. This is some great information. I want to keep it going so we have time to have a bit of a discussion and ask some questions afterwards. So Kemi, over to you.
Okay, I'm just gonna go and share my screen. Hopefully I got this. Okay, can everybody see? Oh, I want to move this out of the way. Zoom is in my way. Okay, can everybody see this okay? Okay, great. Thank you to both initial speakers. That was great and also learning for me as well. So thank you for all of those details. So my what I'm going to talk about today is a little bit is from a little bit of a different perspective. I'm going to talk about the employment experience for justice-involved persons, and as well as employer perspectives that I've been sort of getting to know a little bit more about through some of my research. I'm going to go again, as Smith said, I'm going through this really quickly. So if there are any questions afterwards, please feel free. The first thing I wanted to highlight is just how beneficial employment is for justice-involved persons. And we know that it's incredibly beneficial in terms of integration and reintegration into society, whether it's post-release or just generally, enables people to function. And so we know that it's positive. The Society of Human Resource Management in the US also identified that, justice-involved persons are an untapped labor pool. These are people who are really recognize the value of work to their lives and are many of which are ready to be committed to working and to be committed to an organization. But at the same time, employers continue to be unwilling, or there's limited willingness to hire. Some of the things in the past that have been represented as reasoning includes stigma, which pervades not only across employers, but in society in general. We know this varies by industry, so some industries being more willing than others, but at the same time, there are issues around exploitation. Mentioning back to that study by the Society of Human Resource Management and the Charles Koch Institute, there was some suggestions that employers are willing to hire individuals who justice-involved individuals, but we're not actually seeing anything change in terms of actual action taking place. And so one of the things that I wanted to highlight was a prior study from a few years ago that I did when I spoke with 22 formerly federally incarcerated men. Just wanted to share some of the perspectives that they shared with me when speaking about their experiences navigating into employment. All of these names are changed, so these aren't the real names of the people, just to make sure that everyone's aware of that prior. So in terms of employment accessibility, Oliver spoke about how it was difficult, especially after coming out of prison, to find jobs that actually matched with his skills and experience. In order to find work that actually matched with his skills and experience, he had to omit about 15 years of his actual skills and experience. So there was definitely a bucket of people who, Oliver, as well as Nathan and some others that I spoke with, who talked about having to omit their real experience in different domains in order to qualify for what they were advised to do, which is to apply for general labor jobs, which are generally the industries that are most willing to hire individuals with a criminal history. Another person, Jason, talked about his ambitions to go into employment. And so he wanted to get a real estate license, but was quickly told that, no matter what he did, once he got in front of the real estate board, he was likely to be rejected anyway. So what's the point? Was basically essentially his experience there. The other concern for a lot of individuals was visibility, especially online and with stories being published online, and also in particular the inaccuracy of those. So some mentioned how, in the media, when information is just coming out, that even if that isn't what they're actually charged with, the person's actually charged at the end of the day, that information is out there permanently online, and people have access to that pretty much forever. So that's a big concern. A couple people mentioning, all you have to do is Google their name, and that either, social media or Google will get you, or the box will with employment applications. A lot of people expressed apprehension when they even see any box pointing to criminal history to even apply. So some will just automatically not continue pursuing employment with an organization once they ask any questions around their criminal record history. Someone also mentioned, even once you get a job, there's the concern that what if my coworkers Google me? So maybe they have explained to an employer in the process, they've done all the right things. But then there's that looming concern about, what if somebody finds out and how are they going to feel about working with me? And some mentioning, they're trying to get their name off the internet, which for those that even attempt to endeavor with this is incredibly expensive and a really difficult process. The next piece is the benefit of employment for individual identity. Some people had really internalized, many people had really internalized their experiences being involved in the justice system. Some, like Gary, mentioning that when he looks in the mirror, he feels as though he just looks like a criminal, and he thinks that, when he walks around, people just see it. And of course, if this isn't an identity that anybody wears, but it's been so internalized to the point that they constantly feel like they can be found out, and that's an incredible burden for individuals to bear. Employment for Gary would provide him with an opportunity to identify as something else other than his feeling of being a criminal. Like, I'm a cook, I'm a waiter, I'm an entrepreneur. It's incredibly beneficial. And then Jack similarly expressed that, at the end of the day, he just wants to be happy about what he did today. And so we see how for several people like Gary and Jack, employment would provide them with a positive, something to look forward to and something positive to identify with. So that sort of captures some of the perspectives of, and again, these were just former federally incarcerated persons, so definitely doesn't represent across the persons across the justice system, but some of these themes are definitely relevant across as well. Pointing back to what I mentioned about the SHRM study, so there is a disconnect that we notice because, as I mentioned, employers are saying they're willing to hire, at least in the US. We weren't, at least until this point, quite sure about employers in Canada. They say they're willing, but it's not actually being translated into actual hiring behaviors. The most recent study that came out from SHRM and CKR, the Charles Cook Institute, this year said this very same thing. Nothing's actually changing. People aren't actually getting, more access to jobs. So as I mentioned, most of our data is from the US. And so my colleagues and I endeavored to consider what are the perspectives of Canadian human resource professionals and business leaders. Ultimately, we want to know that for individuals who are actually involved in the hiring process, what are their perspectives towards justice-involved persons? Are they willing to hire? And what sort of things might impact their willingness or not? And so just a quick snapshot of what this study's involved: systematic literature review. We've surveyed over 400 Canadian professionals, and I'm currently in the midst of interviewing. Our goal is to interview 40 business leaders or people involved in the hiring process. We're about halfway at about 20 individuals. I guess a plug there that if anybody is interested in participating or knows someone that would be interested, I definitely like to speak to you. So please reach out afterwards. So some of the things that I'm hearing, one of the assumptions might be that people are just saying they're willing to hire. And it's actually what I thought as well. People are just saying they're willing to hire because it sounds good. And the end. But there was a lot that I've actually unpacked by talking to business leaders. For one, in line with what we would expect based on prior research, the nature of justice involvement matters. So whether that's the severity of the offense, for some, frequency of justice involvement matters. For some, time since release matters as well, but as my last point mentions, jail or prison time generally didn't really seem to matter to a lot of employers that I've spoken to. There was a lot of people who had a lot of empathy for, well, we don't know why somebody went to jail. Maybe they were wrongly convicted. There were a lot of other reasonings around why jail or prison time didn't necessarily matter to them. There was also some mentioning of, unclear protections for those who have received pardons. Those many not even knowing how to approach that, even if they come into contact with that information. Some mention that, as long as somebody has the right skills and they're the right fit, they're absolutely willing to move forward. I'll talk in a moment about some of the organizational factors that impact whether that actually takes place. And some mentioning, it's all about labor market supply or demand. If we're in an industry or if our organization, if there's a shortage of labor in terms of the skills that we require, well, all of a sudden we're all the more willing to consider other groups of people, including people who are justice involved. Another theme, which isn't applied in the exact way across for every employer that I've spoken with, but did come up, is that there are different systems, for lack of a better way to bundle all this together, that people trust. So for some that are in occupations that are governed by regulatory bodies, they trust whatever the regulatory bodies take is on their willingness to hire. In general, as far as I've seen so far, once there's a regulatory body in place, willingness to hire is pretty much not there, similar to the person's experience that I mentioned. In terms of organizational practices and policies, these actually better enable employers to understand what to do if they come across somebody with a criminal record and how they can actually go about hiring. I've found so far that where there is an absence of practices or policies that employers that's where you get the reaction of, I'm not really quite sure how to address this, seems like more work, so I'll just go on to the next candidate. Some mentioned trusting the justice system and saying things like, if the justice system says that somebody did something wrong, well, I guess they did. That wasn't, again, resounding across, but something that's been mentioned. And some, if they had the resources to do so, mentioned getting the advice of employment lawyers. An interesting finding for me has been that organizations communicate willingness or unwillingness. So yes, there's the idea of them communicating it directly. Okay, we're willing, we want to increase diversity, that type of thing. But there's lots of ways that organizations indirectly communicate unwillingness to hire justice-involved persons. For one, some people that I spoke with, if their institution had a level of prestige or had a certain reputation to uphold, they assumed and were very strong in their assumption that they would be unwilling to consider hiring someone who's justice involved. For some organizations, there were media concerns. What would that look like? What would people think? What would our clients or customers think? So again, around reputation concerns. Some had considered justice involved persons as a group that could be considered as a part of diversity initiatives. And for some, even when I asked that question, said, oh, that's interesting. I hadn't really quite thought of that. And so that was another aspect that, if that was already in place in an organization, was positive in terms of organizational willingness to integrate persons into the environment. And then, as I mentioned, companies with policies or practices have a clearer pathway to hire and are more likely to do so. So there was some discussion with employers around what does reform look like. Some of these were interesting. So programming, certification, education kind of expect references or someone's social network, people that are willing to vouch for them, housing and being married, I found to be interesting. Heard that from at least one participant as indication that somebody has been reformed. So that's interesting. And then this was actually noted by my US colleagues that are involved in this study that have also done some of the interviews as well. They said, because they've done interviews in the US with US employers, and for them, Canadian employers just sounded different in terms of their motivations to hire. So a lot of the people that they've encountered in the past are more empathetic and willing to consider justice-involved persons, either because they've been personally impacted or have been exposed to individuals in the past, or maybe based on how they grew up, and again, just knowing somebody or being personally impacted themselves. But they found for Canadian employers, it wasn't about that. It wasn't about necessarily having experience with someone who's been justice involved before and having to make that personal link. People generally want to, as they've expressed, give people a second chance and really at least in terms of willingness, would like to aspire towards diversity and inclusion. I'm not going to go through this because I'm pretty positive I'm probably over time, but I just wanted to share this. It's a working checklist that I've come up with, and just based on both my research and in speaking with employers, this is really meant to address the thinking around, if you're someone involved in hiring, or for those like involved in an organization, and you're trying to think about, okay, what can I do to understand, do we have an inclusive working environment? Where do I start in terms of trying to be a more inclusive environment where there's equitable access to employment for justice involved persons? These are some of the questions that I think might be helpful to ask yourselves. And so I'm just flashing it up there, and happy to share at any time or go through this further. Thank you.
Thanks so much, Kemi. And we'll turn it over to Avery, and then we'll jump into some discussion.
Okay. Great. Everyone can hear me? Okay. Thanks, Kemi. That's a great intro, actually, for my presentation. I'm just going to pull up our slide deck over here. So I'm going to speak to the Fair Chance Hiring Campaign, which is an Ontario-based campaign, the first of its kind in Canada, that is targeting employers to help them adopt more inclusive hiring practices, and specifically help them hire people who have criminal records. But there's quite a few little nuances that are kind of important to understand. So that's kind of the goal of my my presentation now, is to kind of walk you through what exactly do we mean by fair chance hiring, and what's the ask that we're making of employers. And then, happy to answer questions in the moderated discussion. So this deck actually is a deck that we use to help recruit partners, but I'm just going to go through it pretty quickly. Sophia mentioned, approximately 4 million Canadians have a record. And of course, these people are disproportionately from racialized, marginalized populations. And there's research that shows it can reduce your employment chances by 50% or more. This is a really interesting slide because before I came onto John Howard, they did some really rigorous polling of public opinion. And I think the result was actually somewhat surprising, the degree to which Canadians support second chances. So people who have, served time, that they get a chance to work again. And they also indicated that they would support companies, it would impact their purchasing decisions if a company had a better, equity practices that included second chances. So let me just break down what exactly do we mean. So it does not mean going proactively seeking out people who have criminal records to hire them. So that's not what we mean by fair chance hiring. What we mean is that if someone is a good fit and the employer believes that they're qualified to do the job, having a criminal record shouldn't stop them from hiring that person. So it basically, it's allowing everybody, even people who have criminal records, to be fairly assessed for a job. So in order to get an employer to that point where they can, if they see a criminal record, they know how to react to it, that takes a lot of work. So that is like changing hiring policies, as was, Kemi mentioned, ongoing education and training for, hiring managers, not just HR, and also coworkers, not just hiring managers. So there's a lot of, let's just call it slow, difficult work that needs to be done. The way that we're pitching it to employers is not even, it is about social equity, but we're at least equally pitching it as good for business. And there's a lot of great, content from the US that basically says, increased employees or people who are giving a second chance, they usually are more committed to a role with fewer absences and turnover. And of course, they're accessing a larger pool of candidates, especially in this time where, people are finding it very hard to find employees. Our campaign is broadly modeled off of the US experience. And, the US criminal justice system is very different in the sense that it's like far, far worse. A global aberration is, I've often heard that phrase. But at the same time, that's led them to have a lot more of a robust response to try to fix some of these problems. So since, over the last decade, there's not only been kind of companies adopting all these policies, but also legislation at varying levels of government. And I think what's really neat is that, the reason we call it a coalition is because not just employers, it's HR professionals, background check companies, like everybody has a role to play in changing people's attitudes and beliefs. Okay, so yeah, I just want to make clear that this is a voluntary campaign. Like the John Howard Society and the CCLA did great work to pass the Police Record Check Reform Act, which helped address a lot of really outrageous injustices. But legislation can only go so far. Right? We really need to inspire employers to believe that this is the right thing to do. And I just want to give one, I suppose it's an anecdote, but it's one kind of complication. So in the US, there's this policy called ban the box. So the box being, that little checkbox that says, do you have a criminal record, yes or no? If you check it, your application goes in the garbage, right? So that's actually not as common in Canada. But in the US, when they banned the box, 5 to 10 years ago, it was very surprising that the economists and social scientists found that the outcomes for the target population, so like young Black men, were actually worse. So like people got less jobs when they removed this information, when they banned the box. And the reasoning is that when employers are denied information about criminal records, they're just going to fall back on plain old racism. So, they're just going to believe that if a Black person, if they can't know whether or not they have a record, they'll just assume that they have a record. So that, on the one hand, that's a very depressing fact. But on the other, it kind of goes to show why our strategy is different. Like we're not, so for example, the spent regime that Abby mentioned is about kind of expunging information, removing information. But this is about actually having these conversations with employers and trying to actively change their minds to say what actually about a criminal record is so bad, is so terrible that prevents you from hiring someone. Okay, I'm going to wrap up really quickly. So there's 3 main pillars of the campaign. It's going to be launching next month, so stay tuned to our social media, John Howard Society of Ontario. So first, we are going to help employers adopt improved policies and practices, essentially so that they know how to evaluate a criminal record fairly. We're going to ask employers to commit to this ongoing training, and there's lots of great examples from the US of this type of corporate training. And then lastly, we want to do a public awareness campaign. So storytelling, that kind of thing. So I'm going to wrap up from there and happy to take your questions.
Thanks so much. And thank you to all of the panelists. There's been some great information and I'm going to jump in with a couple questions. I think there are a couple questions coming into the Q&A function and the chat, so we'll try and get to those as well. We've covered sort of a couple different perspectives on how to address this issue. We're here talking about breaking the stigma associated with a criminal record. So we've heard about sort of removing that barrier altogether with record suspensions and talking to employers and things like that. Just want to throw out a question to all the panelists about sort of the role that the legal profession can play in breaking down the stigma of criminal records, removing the barriers that exist for justice-involved populations. And I know our audience today has a diverse group of people, so that covers lawyers, but also sort of nonprofits, service providers, et cetera. So if you want to include that perspective in your answer, feel free to do so. If anybody wants to jump in first, otherwise we can just sort of run through in the same order that we did the initial intros, starting with Samantha. And feel free to pass it if you want to sort of pass on to a next question. I know some of these, some may be more comfortable answering than others. So I want to give everybody a chance, but feel free.
Yeah, the first thing that comes to mind, and I'm not a legal professional, so, but there's a document that came out a couple of years ago, I think from the Canadian Bar Association. I can go quickly look at it after. And it asks legal professionals, including lawyers and judges, to really consider the collateral consequences of punishment in the throughout the sentencing process. So, you know, when someone is going through the courts, that things like the impact of a criminal record, you know, the length of a sentence, the amount of time that someone has to wait before getting, you know, a pardon or a record suspension, and the consequences that come of that, you know, not being able to get employment, not being able to secure housing, not being able to volunteer, all the things that we know, for legal professionals to acknowledge that in their work throughout the system. So that's something that comes to mind right away. And then also working on you know, human rights protections and privacy. So one thing that Kemi brought up that comes up in my work all the time, that people are always talking about is Google searches. So whether or not, even if you get a pardon or a record suspension, even if your record is sealed, you know, that Google record is still going to exist, and employers and landlords and volunteer coordinators will use Google. You know, we all get Googled when we apply for a job. And there's some work in some provinces and in other jurisdictions on, you know, the right to be forgotten legislation that could be applied here. So I think that's something for folks to think about as well. So just those are my quick thoughts.
I'll take a turn. So I mean, there's lots of law reform targets, right? So there are all kinds of ways that the law itself relies on stereotypes and stigma and how it treats criminal records, and reinforces those by requiring they be considered, by asserting that they are relevant to credibility, right? Something as basic as, you know, a person's credibility before a court is currently influenced by criminal records. So I think like every single lawyer, no matter what your practice, probably has some touch point with this discriminatory stigma that's associated with this record that can be pushed back against in a lot of different ways. I mean, certainly, you know, we are prioritizing Criminal Record Act law reform, but even looking at lawyers' own regulatory bodies, right? Like, how does the Law Society in whatever province you're practicing in treat criminal records and the good character assessment? All of those are legally reinforced processes that in a lot of ways double down on stigma and discrimination. And then just, you know, supporting clients, connecting clients with us or with the organizations that are working on advocacy and reform in this area can be very, very difficult for people to know who to reach out to. So making sure that you have those resources at your fingertips so that you can pass those on to the people that are experiencing these barriers and make sure that they have the tools that exist.
I'm sorry, Sophia, I'm a little bit bad at multitasking. I was responding to a question. So can I please just hear the original question really quickly?
Absolutely, yeah. So, and thank you for responding to those questions. If others want to sort of send in written questions, we're trying to respond to those as we go along. But the question was about the role that the legal profession, and there are others on the call, including sort of service providers, nonprofit, other sectors, but what role can you know, that legal profession play in addressing this issue and breaking down the stigma and getting access for justice of all populations?
Okay, great, thank you. I guess because I'm, of course, not from the legal profession, I'll just speak really quickly in terms of what I've seen. And when people are reaching out to employment lawyers, it's an opportunity for you know, people to help employers understand how to provide for equitable access, and even just making it not seem, I'm not saying that everyone makes it seem daunting, but just sort of walking employers through the process in terms of what it can look like, I think is a main way that I've seen that there can be some movement.
Sophia, I can jump in there. Yeah, so for our campaign, the Fair Chance Hiring campaign, there are very, very specific ways that lawyers can get involved. So for people who are in the employment space, as Kemi kind of suggested, like we want to create a lot of content and, you know, hearing, you know, professionals talk about kind of what are the true risks. Like people really often don't understand vicarious liability, or they think that negligent hiring is a thing in Canada, which it's not. nor is it, I think, very large in the US either. So there's a lot of kind of conversations that need to be had by employment lawyers. And also, we also have, seeking for collaborations with criminal lawyers to explain what charges and records mean, right? Like if you're given a piece of paper with basically it's gibberish to anyone there. Kemi, in my conversation with Kemi earlier, we were chatting and when she asked people, why do you check criminal records? Like, I don't know. Like nobody actually knows what to make of that information. So it's like, it's kind of just like receiving a sticker. And that is really what stigma is. Like, there's no understanding of what that means and doesn't mean. So getting help from criminal lawyers to explain, this is an assault conviction. This could mean one of 20 things. People start to realize how little information is actually being communicated in that record, especially for kind of lower level offenses. So yeah, we need help from lawyers and also, of course, donations help as well.
Great, thanks so much. So there's one question in the chat talking about sort of what to advocate for, what should be the ultimate goal, and is it automatic expungement? So I wanted to put that, maybe Samantha or Abby might want to answer that specifically, but others are welcome to as well if they have thoughts.
Sure, I'll go first. And then Samantha, you add on. So expungement, as Samantha mentioned, was a very clear and very important focus of the Cannabis Amnesty campaign. The campaign that we are doing, we think works alongside that. So we, the way we are approaching it, we're not asking for expungement. There are reasons why people's criminal history can be relevant to justice system processes, right? So the stigma and consequences that we are really focused on are the stigma and consequences that flow in employment, in housing, in travel, in all of these spin-off areas that are really collateral consequences of the justice system. We are focused on a very broad automatic suspension or spent records regime. We are not, tailoring just these types of offenses or just those types of offenses. We think it should be automatic and it should apply to everybody. And when you do that, and if you want shorter timeframes, you are going to be sweeping up a lot of records. So for us, we're asking for suspension, not expungement. So those records will still exist in some policing databases, which I know will have consequences for people down the road. But if we want to assist people in a timely way, in a very concrete way, in terms of getting jobs, getting housing, and some of the really basic social stabilization factors that will help to rehabilitation and reintegration, we think that encompassing all the records and making it automatic for those purposes is going to be extremely meaningful. So it's definitely a point of discussion, and it's a point of difficult discussion, frankly, where there are some trade-offs to think about.
Thanks, Abby. Did anyone else have any thoughts on that, or we can jump into a different question? So we've touched on this a little bit, but I want to talk about just, and this is to all panelists, just about the main barriers to sort of reducing the stigma, to ensuring actual access to jobs for people that are justice involved, especially with compounding issues. So Kemi talked about racism, and there's other factors in play that can affect individuals' ability to access employment, especially with a criminal record and the stigma involved. What would you say are the main barriers for sort of addressing this issue? Is it looking at policy and legislative changes? Is it a cultural shift that's needed? Obviously, a lot of these things work together, but just to touch on your perspectives around that, and what else needs to be done. We've heard from some great campaigns here today, but what do you see as something else that really needs to be tapped into to address this issue? We can go back in order, or if, sorry, if you want to jump in or
quickly. I was actually just typing the response to that, to Ben's message, and I guess my thinking is that So I've thought about this question a lot. It's kind of like comes down to like theory of change. Like, how do you think society is going to evolve? And of course, that's a super complex question. Nobody knows the answer to that. But broadly, like from a way I think about it is there's a spectrum, right? So top down or bottom up. So bottom up is the idea that you start to change mass opinion in your favor. So like same thing like same-sex marriage. Like, how did that change so fast? That people often say there's a bottom-up theory for that. Whereas top down is kind of like, well, we're going to talk to the policymakers, we're going to talk to politicians or the elite members of society, and they will just implement it, even if the public doesn't support it that much. So I think like the answer is basically all of those things, and then you just where you are on that spectrum. And I think the thing with the equity like the reason why we're very hopeful about the Fair Chance campaign is that it really makes sense within a lot of the cultural changes that are happening right now. Like their employers are really doubling down on equity and inclusion. And this fairly fits like right in the middle of their concern. So I think all different groups of society have different roles to play, and they're complementary.
Yeah, I guess I'll add that I definitely think as both Sophia and Avery have mentioned that it's almost an everything. It's not like one thing alone isn't going to be isn't going to do everything. It takes both individuals being willing, as well as I think from the top down approach, it also makes me think about the way that so when I talk about indirect communication in organizations, support from leadership for including more than just the traditional groups in equity and inclusion initiatives, I think is important, as well as individuals thinking about, as Avery mentioned, like where do I sit in this space? What influence can I have potentially? And I think a big thing too is education. So people both making an effort to become more educated about the realities, as Avery pointed to, there are a lot of things that employers are worried and scared about that either don't exist or don't exist in the way that they envision them to in terms of risks and liabilities. So I think at the individual level, think about how we can all get better educated, as well as from the organizational perspective, thinking about how we can better educate staff and ourselves if we're in a managerial position to be able to make for a more inclusive environment.
Thank you. I don't know, Abby or Samantha, talking about barriers and what else needs to be done on this issue.
Yeah, I just want to chime in quickly just to echo, of course, like coming at it from all angles is important. Just to share quickly from my own research. So I interviewed frontline workers. So people working for organizations who, support folks with records in the community. And so talking with people like employment counselors and housing caseworkers, that's where their work is. They're doing this like everyday advocacy piece, with employers and landlords kind of, doing that anti-stigma work with every conversation that they have. And, when they're able to actually connect with an employer and have the conversation about, the folks in their program who they're trying to get employed and, the experience that they have and the skills that they have and what they would bring to the employment, then, most of the time it works out well. But when they end up in situations where you can only apply for the job, online, or there's no kind of, face-to-face opportunity with the employer, it becomes a bit more difficult. So as things move online, it's getting tougher. And as we've heard, as soon as people see that question or that box, they're likely to step away and find another opportunity. But I think, those everyday conversations are super important alongside the broader kind of structural change that we need.
Okay, I don't know if Abby had anything to add there, or we can move on. We have a bit of time left. So I'm just keeping an eye if there are any other questions that come through. But I wanted to ask, maybe we've talked about what we're doing here, but maybe if there's any other lessons from other jurisdictions, where do we stand? Where does Canada stand or Ontario stand in terms of this issue? And are there other jurisdictions that can teach us some lessons in this regard? I'll throw it out there for whoever wants to jump in.
I can talk about this, and I'm sure Samantha can as well. I mean, so there are definitely other jurisdictions that have spent regimes where records automatically are suspended or expire. If you look for it online, you will find examples from Australia, the United States. The UK has had a spent regime for decades that's in place. But I actually think the best example, the UK is a good one to look at, but I actually think the best examples are Canadian examples. We have had a legal regime for our youth records that has automatically suspended youth records for many, many, many years. And we have very successfully decreased youth incarceration as well as crime rates in youth criminal justice. So, that is an example of a very good Canadian spent records regime that works really well. So I don't actually think we have to look very far in order to think about how this might work and to gain some confidence that, this does make sense and it's completely workable in Canada. We also have had a lot of, we haven't talked about it at all here, but there's been some legal reform at the provincial level on non-conviction records and removing those from records checks that has been, I think, successful, although has some problems. So we do have examples right here in Canada, and spent records regimes have been proposed in Canada as well in the Senate with Senator Kate's bill. So there are lots of good, readily available legislative examples for how you might enact this.
I'll just quickly say, yep, everything Abby said, but also that, Canada used to be a leader in this regard. Like our pardon system was upheld as an example of what to do, post sentence and to help people, to have that burden lifted. And it only took a couple of years to completely undo that. But Abby's right. We have examples here, it won't take much work, to be honest. It just some or a lot of political will to make it happen.
Great, thanks so much. So there are a couple sort of more specific questions. I know there was a question in the chat about, if you have a pardon, what they can see when you cross over to the U.S. border. I think there was also a question about the change in sort of the record suspension system from 7 to 10 years. So if speakers want to answer those questions, otherwise they can also be addressed sort of in the chat as well, if folks prefer.
I have a really short answer to the travel one. And sorry, there's some noise happening in my building, so I'm sorry if you can hear that. With the records at the border, the information is very messy, and I kind of hear different things all the time. But the short answer is that the U.S. doesn't recognize a pardon or a record suspension. So even if you have received that and you get to the border and they deny you based on your record, and you go, but wait a minute, I received a record suspension, they don't have to recognize that. There is a system, you can apply for a waiver, which is again another whole series of paperwork and costs, and so it is very complicated. I can pop my email in the chat if people have questions about that and want to know more. I'm happy to do that. Yeah, that's my quick response for that.
Great, thanks so much.
And I'll take a stab at why was a pardon extended from 17 years. I mean, no evidence-based or good reason. It simply was tough on crime politicking and looking to message that you cared about public safety and were punishing people, right? So like that was a theme coming from our federal government for a very, very long time and continues to resonate. You will continue to hear tough on crime messaging coming out from different parts of the government. And I think we continue to have a federal government that is timid, to say the least, on justice reform. So it's about politics.
Thanks so much. So we're near the end. And so I think the one thing I might leave folks with, the last question, if you want to, anybody can jump in and answer this just briefly, is just to share, something that might be sort of misunderstood about this topic. I know when I started looking into this issue a few years ago, there's a lot that I didn't realize, and you've shared some great information during this presentation. But if there's anything you wanted to share in closing that you believe to be misunderstood, or that you believe is really important for folks to understand, especially around shifting, making this cultural shift and reducing these barriers for around the stigma for justice of all populations. I'll allow you to do that, and then we'll wrap up for the day.
Yeah, can I jump in quickly, because I'm seeing some questions come across about concrete actionables, and I think it dovetails well. So I would have two, and they unsurprisingly stem from the two concrete suggested pathways to change that were suggested on this call. So the first is get in touch with us. Like, what can you concretely do to break down stigma and break down barriers? So we are focusing on Criminal Record Act legislative reform. There are lots of other things you could focus on, but for various reasons, we think there's a window of opportunity, and we're trying to take advantage of it. So if you are a lawyer or positioned with an organization that would like to support legislative reform on this front, get in touch with me, please. And then the second is, what else can you do? It's the Second Chance campaign, actually. We all are working in our own organizations. We all have family members that have workplaces. We are doing education. We are doing volunteering. We are working in the schools. And every time we interact with an institution or an organization, that's an opportunity for questions to be asked about how your own personal circles, your own personal organizations are dealing with this, and an opportunity for education, right? So what can you do to break down the stigma and barriers? Have those individual conversations, ask the questions about what are we doing about this? And then if there's education needed, invite, I'm going to nominate Sophia and Avery, but invite the people who are working on the Second Chance campaigns and Kimmy to come and talk about, what are the impacts of this? What are the misconceptions? And, broaden the circles of education and awareness so that you can continue to push this in your own individual circles of influence. And I will put my email in the chat again.
Thank you.
Yeah, I think just to build on this, maybe overlaps a little bit with other jurisdiction questions. I feel like everything that we talk about is very doable. Like, I feel like in a lot of criminal justice conversations, things can get very depressing, and people can talk about the lack of progress and things like that. I think it's helpful to point out that most of these measures are implemented somewhere else with no problems. So, for example, British Columbia and Quebec, they actually have legal protection for people who have criminal records. So namely, like, you can't discriminate against someone on the basis of a criminal record in employment if the record's not at all relevant to the job. So that's already true in a couple of provinces. It's true in a lot of different US states. It's true in all of Australia. And there's no, like, there's no like material difference. There's also industries that don't even check records. So like construction being one, film industry, when we spoke to them, they also don't, there's a practice of not checking records at all. So anyways, I just feel like this cultural change can happen, and we could, also like be optimistic and about making that happen.
Thanks so much. Samantha or Kemi, any last thoughts?
Yeah, I know the focus has been on employment, and that's obviously super important, but also one thing that comes up so much is housing, and increasingly, criminal records are becoming a barrier to rental housing. In cities like Ottawa, we have, what's facilitated through the police is a crime-free multi-housing program that encourages landlords to use criminal record checks as part of the screening process, and it prevents a lot of folks from getting housed, and then we know that housing is also a precondition to employment. So it all it's all feeding into one another, and I think another area of focus is stopping people from being criminalized in the first place and preventing all of this. So I think all of us, can do what folks are doing, and I know there are so many people here that do, but advocating for decriminalization, advocating for alternatives to policing, to incarceration. So just preventing all of these consequences, in the first place, and kind of shifting our focus in that regard.
Yeah, and I guess what I would add from an employment perspective is that, one thing that I think we've learned from the general social movement around equity and inclusion is that, or I guess one of my big takeaways is that there's no real norm in terms of what people are facing or dealing with, and that's exceptionally true for people who are justice involved. And I think a part of equity and inclusion is considering the diverse nature of experiences that people bring to the table that both sort of shape who they are and also can influence the impact and the nature of diversity that individuals can bring to the table. That being said, I think a big thing for me too is just is letting voices be heard. And again, that's what I think is a general big implication of EDI. I've met several people who, when they're applying to jobs, they will say in their cover letter, just so they get it over with, even if the question is going to be asked, I have a record, and they want to explain. So I think in some way, enabling people to express their voice, no matter when in the process a background check occurs, maybe a part of the shift, whatever that shift in policies or procedures an organization might be, I think would be to allow somebody to express their voice and explain and tell you more about them, humanize the person, and don't limit them just to their to one aspect of their identity, which nobody wants to be tied to forever. So that's what I would say.
Thanks so much. And I see that we're at the end of our time here. So I think it will wrap it up, but I want to thank all of the panelists for sharing your information today. And thank you everyone for tuning in to this discussion. I think the main takeaway for me is that there's so much that we can all do, and so many ways we can tap into the existing work on this issue. And it does have a profound impact on individuals' lives, but also the communities that we all live in. So thank you so much again for today. I appreciate it. And